Hazel, as the next dean of Yale, do you want to have any comments to reply?
Just a couple. So on the interpretive picture and the fact that I don't really talk about the words necessary and proper so much, I think the answer is, that this takes us back a little bit to the question about big data versus being a sophisticated linguistic user of something in the air. The Constitution is adopted against a backdrop of a lot of legal understandings and legal principles. And I think there's, they tell us during the Federalist Papers that the necessary and proper clause doesn't mean anything different than the Constitution would mean if it weren't there. That you have some idea of what powers are implied in a list of powers like the Constitution. And they have a bunch of different predecessors about, how to interpret that. It would be nice if they were maybe slightly more grounded textualists about that, and so we could focus on the words proper and necessary in a little bit more of a dictionary sense, but there's just good reason to believe that's not how they thought about it. I do think it's interesting. I think McCulloch is a good point in both directions. I think it's true, obviously, that John Marshall in his heart of hearts may well have believed in plenary federal power, and he's careful in the Great Substantive and Independent Powers passage not to give anything very important away, because he doesn't give away any specific powers that aren't granted to the federal government. At the same time, I think it's telling that in a relatively nationalist opinion that's clearly sort of moving the ball in that direction, this is still a principle that he, for whatever reason, thinks he needs to sort of bow to. That's a sign, I think, that it's actually an important constitutional principle. And that's kind of the thing about the politics story, too. It may well be that most people, at most periods in constitutional history, are making constitutional arguments for other reasons, because they really like the results that it gets. But constitutional law shapes the arguments that are available to them, and the fact that the fact that this is a prevailing argument for so long, I think is a sign that it's a much more robust part of the original understanding than anything else. I think everything else can wait until other questions.
Okay, we have a quartet of troikas here. And so Chris, the first troika is Chris Green, Larry Solom, and Earl Maltz.
So I don't know much about necessary proper clause, but why isn't this maybe the right picture? Great means kind of big relative to how much the federal government has exercised other powers, or something like that. A greater in dignity, or not lesser in dignity, according to Lawson and those guys. That's going to depend on how much power they've exercised in general. And right after the Civil War, you look at the 1815, the power to suppress insurrections. Well, think about Fort Sumter. The Union defends Fort Sumter, and they're like, they didn't defend Fort Sumter enough. They think, wow, wouldn't it have been great if Fort Sumter had been a lot bigger? Suppose there's this, secessionist movement in, some state. We've got federal forts out there. We're like, we could really prevent an insurrection if we had a bigger fort, a lot bigger fort. So we go to that state and say, hey, can we have a bigger fort? And they're like, no. Given the prevalence of secessionist thought being much bigger than they thought, like it's really like 11 freaking states, might that affect the analysis of what counts as great in a way that I think would justify Cole, maybe?
Larry?
I just thought it was a wonderful paper, and despite Marty's heroic efforts, still utterly convincing, except you knew there was a but coming. So just on the on your reply to Reddish, right? So we've got the necessary and proper clause, and let's just accept that it's intended, the purpose is for it to be redundant, right? Nonetheless, they put it in, right? The Constitution now includes the necessary and proper clause. And as I see it, there's sort of a couple of ways you can go here. If you want to go a public meaning route. So you can accept that necessary and proper have semantic meanings and try to cash those out and show that great powers is either built into necessity or it's built into proper. but the paper doesn't do that, right? Or you could say necessary and proper is a phrase of art, that it had a technical meaning. Maybe you could rely on some of Builder's works there, but you don't do that either, right? So what have you done? What you've done, right, gets you a long way to where you want to go, I think. What you've done is you've shown that sort of whatever the text means, the people in the period believed that it had this implication that great powers are not allowed unless they're enumerated. But now you run into sort of the Mark Greenberg, Jack Balkin point about original expected applications, right? Except their point is more general than the application to specific tokens, right? You can have original expected beliefs at a higher level, at an abstract level. So you've established an original expected belief that great powers are not authorized by the necessary and proper clause. But until you make the connection to the text, you don't have a public meaning argument. You could go another way. You could argue that there's some form of original intentions originalism that licenses this move. But of course, you don't do that in the paper. So I'm convinced by your argument, but I think that there's a missing step in the argument, right, that would connect some specific form of originalism to the great powers move.
And Earl.
I hope this is not too half-formed, but or half something else. When you were talking about the distinction, the way the eminent domain clause worked, through the states, the federal government used, and B, that they can use directly in the territories, it made me think about arguments about the reasons we have an enumerated power, the doctrine of enumerated powers. It seems that they're usually for two reasons. And the number one reason is to protect the people. And number two, and secondarily, it seemed to me, doctrine of enumerated powers was talked about to protect the sovereignty of the states. It seems to me that the way the eminent domain power works sort of flips that around. That is, first of all, when you go through the states, you can basically have the same effect on the liberties of the people as if the eminent domain power was granted. And B, when there aren't state governments intervening, as in the territories, the federal government has the can exercise this eminent domain power. So as I said, this is kind of a half-formed thought right now, but so it seems to me that this whole discussion has very important implications about the entire nature of the doctrine of enumerated powers, which in turn, and here I haven't worked it out at all, might have implications about what the extent of the how the doctrine of enumerated powers ought to be applied. And as I say, it's a half-formed thought right now, but that's what the paper made me think about.
Okay, well, you've got three on both.
So we'll start with theory and move to practice. So on Larry's question, I think there are a bunch of different, you could run this through a bunch of different versions of originalism. I think at a technical matter, the great powers idea is consistent with saying this is what proper means, that necessity is about the means ends test and proper is about consistent with the spirit of the Constitution and not otherwise an elephant being hidden in a mouse hole test. I don't sort of put it into those words, in part just because I don't see a lot of that in my own sources, and I don't want to sort of run it through my own anachronistic word choices. Similarly, I think it's tempting to see necessary and proper as a term of art, but there's some evidence from Nielsen and Lawson that words like necessary and proper and a couple of cognates are all kind of thrown around randomly during the pre-constitutional period with no real sense of consistency or pattern. So I'm not sure that that's right either. And so I just try to run with what I have, which is I think they look at the phrase as a whole, and this is what people say in public the phrase as a whole means. And it would be nice to be able to sort of sentence diagram too. I just don't know how to do that yet. And I do think that that means that if you subscribe to something like Jack Balkin's version of originalism, rather than, say, Chris Green's version of originalism, that makes it possible to get away from the argument. I just think that may be the way it is. On Fort Sumter and relativity, I think this is a possible way to understand great powers. This is kind of greatness is relative, or the implied power is relative to the granted power. I don't know whether that's right or not. I don't have strong feelings about it. If it is right, it might actually explain a few of the suggestions that there's some kind of eminent domain over personal property with respect to military powers. That might be what's going on, is the military powers are really big. So, some limited amount of eminent domain is not necessarily great relative to the military powers. I don't know whether that's right, but I think it's a fair question. One minor thing about Fort Sumter, which I just have to say, South Carolina actually attempted to exercise eminent domain over Fort Sumter at the start of the Civil War, in an attempt to, just during the jockeying over who could control it and who couldn't. But they failed because it was owned under the Enclave Clause and therefore part of exclusive federal jurisdiction. I couldn't figure out any reason it was actually relevant to the paper, but I wanted to say it. As for states and territories, I think the picture here is consistent with what I think is kind of the mainstream theory that federalism exists to protect individual liberties in this kind of roundabout way, which I guess is the belief that at a practical level, if the national government can't do it and it needs the states to sign off, often the states won't sign off because for various reasons we think they will be interested in protecting the liberties of their citizens. It's true that doesn't work in the territories, but that's just a consequence of a system where there's close to plenary power over the territories, and I don't know if there's anything special about eminent domain that makes that more of a problem.
Can I? A couple of things. Larry, when you were complimenting Will's paper, somehow I free associated to Shakespeare's Julius Caesar and Octavius's funeral oration referring to Brutus as an honorable man. Because you seem to, after all these compliments, you seem to devastate the paper by pointing out a rather major gap, it seemed to me. And Chris, I thought you were going in a different place. I thought you were, although I had no reason to expect this, that you would sort of be on my side on this when you're pointing to Fort Sumter, where they say, holy crap, we can't rely on these state legislatures. These are loose cannons in the both figurative and unfortunately literal sense at that point. And that was an awareness. And I think Will's concession in the paper that had this not worked in the early part, this meaning the use of state legislatures, they would have been very quickly back to the drawing board. That the government needs property, not only military property, but implementing a lot of its powers. And to be at the mercy of state legislatures ultimately proved to be a very unreliable source.
All right, Will's got a Sir rebuttal here.
So two things, I guess. One is there's a difference between how the Constitution works in practice and what it means in theory. So the fact that the Constitution, the original meaning of the Constitution, turns out to have bad consequences might mean we don't follow it. That doesn't necessarily mean it wasn't the original meaning. The other is this is a deep problem with federalism, is it's often hard to tell the difference between a feature and a bug. Is it good or bad that the national government lacks the power to militarize the states and force them to do everything the federal government wants? People who won the Civil War would say it's bad, but at the founding, people might have thought it was good, and it's hard to know ex ante what powers the federal government is supposed to have unless you have a view of whether the federal government is on your side or not.
I think you just made the argument against originalism.
Maybe, if the federal government's on your side.
The next troika here is Randy Barnett, Nathaniel Chapman, and Greg Maggs.
Great paper, Will. I just want to push back a teeny bit on the small section of the paper in which you deal with the individual insurance mandate. And in the paper, I think you suggest that it is that NFIB is somewhat questionable on the great powers theory. And my instincts are really the opposite of that, and partly because I view the individual mandate, or the power to impose economic mandates, the power to compel that citizens do business with private companies and send their money to private companies, is very close to a taking. It is so close to a taking that people, during the course of litigation, urged us to make a takings power argument, power, and we didn't do it because case law, would not have been friendly to us, and it just would have made us. I think it would have weakened our argument litigation-wise, not strengthened it. But conceptually, it was actually a very powerful argument. This is like a taking. it's taking somebody's money and sending it to a private company. Now, you could say, Epsteinian-wise, there was an implicit in-kind compensation that you get insurance policy in return, and so therefore it's compensated. But the taking part of it is there, and it's just because it's money going to a company, it doesn't look like a historically taking, like a personal property taking. I mean, like a real property taking. So in that sense, it's so close to a taking that it would seem that that what you've discovered about takings powers not being a federal power. I realize you have these two. You say there's these two historical examples of where there seems to be mandates associated with other powers, and therefore that power may not be totally extraneous. But some of these are arguable examples, possibly, and justifiable in other ways. And so I guess for that reason, I kind of agree that I don't think this paper really tells us specifically one way or the other about it. But it seems, I think, really the weight of it seems to cut more in the direction that this is a power, and one last thing, I'm sorry, and this is a power that, with these two exceptions that you may have, that are associated with other powers, this is a power that under the Commerce Clause has never been done before. So even federal takings have been done, but this one hasn't. This was so far beyond a taking of property for public use that it never was, that Congress didn't even try it. So that's a further argument for why this was a great power, because if it had been a power that Congress had, they would have used it.
Nathan. So, you know how much I like your paper, Will. This is going to be an annoying permutation on the conversation we've had ad nauseum about it. But it made me think of this presentation, and partly Larry's comment as well. So first question is, do you think you're doing some sort of original legal meaning methodology? Insofar as you're doing some specific methodology there. And if so, does your paper suggest an implication for that kind of methodology in that perhaps the legal meaning is more dynamic than other forms of even original understandings? So such that a reasonable lawyer after the Civil War would have just known. Someone who had lived through the Civil War and put on the Supreme Court afterwards would have known. And so do you think this says something about that form of methodology? Also, most of the papers that we're discussing that are Reconstruction era papers focus on rights, because obviously those are the amendments, the changes to the text of the Constitution. But I wonder, based on your research, whether you think there's a lot of interesting information about changes in the scope of federal power and just the expectations about the scope of federal power that were widespread during Reconstruction, quite irrespective of the rights.
Larry?
I just was asking to keep it at the end of the queue.
Although actually, if you wanted to make a quick response to Marty's point, since it was direct to you.
Well, okay, so
I think-
it is
I think
in
we're
response
within
to
the rule.
Marty's point. I just didn't want to interrupt things. So if, Larry, this is your call. I just was going to respond directly to Marty. And it will only take 30 seconds.
You want to elevate Marty to Yale's deanship?
I do.
I don't think he has the effect when he criticizes. It's something unique to me.
All right, well, I'm worried about establishing
I understand.
wrong precedent on this one. But
I thought we didn't believe in precedent.
unless somebody wants to cede the next person.
I'll see. Thanks a lot.
The next person on the queue is Greg.
I'm happy to let you go first, but I think you didn't ask to go first, so yeah. I just have a comment and a question. I mean, this is a very extraordinary paper. I had no idea that the federal government did not exercise the power of eminent domain in the early history. That calls for some explanation, and while your inquiry and explanation may not be 100% watertight, I'd like to see something better before thinking that yours is not the correct view. The second point I'd like to raise is that I had a very interesting student paper in a seminar last fall about Barron v. Baltimore. And what the student's inquiry was about is, why was this litigated for so many years at such great cost? When it gets up to the Supreme Court and Marshall just says, Bill of Rights doesn't apply to the states. That's ridiculous. And one thing the student pointed out in the paper was, I think, something that Mike McConnell had written, which is, if you read the Fifth Amendment, it doesn't say Congress must pay just compensation. It just says just compensation has to be paid. And I was wondering, could it be that there's some explanation here that the thought was that just compensation should have to be paid when the federal government relied, that the states would have to pay just compensation, or somebody had to pay just compensation, when the states relied on the state, the federal government relied on the state's eminent domain power. And you talk about how many states did pay this compensation, and you said some paid even though they didn't have a requirement to do so. I was wondering, well, could that be an explanation for the Fifth Amendment not referring to Congress for this idea that people thought they were entitled to just compensation under the Fifth Amendment, even though we have the notion that the Fifth Amendment normally applies to the federal government? That's it.
Okay, Will, you got three teed up here.
Sure. So the mandate, Randy, you make a lot of good points, and I know you can make even more good points in favor of the mandate. I think the short answer is it's kind of hard to know what the right historical answer is. So I think, what really does the work is what your theory of judicial deference is. And I don't know whether a weak theory like John's would be enough to uphold the mandate, or do you need something more like there's a slightly stronger version of it. But I think it ends up being a big question, just sort of the big question of what do you do when you come to a kind of conclusion that's a little bit vague about how broad the necessary and proper clause is, and who bears the burden. Is it Congress because they're asserting the power, or is it the challenger because they're asserting the unconstitutionality? And I sort of run with a kind of basic, sort of the normal laws are presumed constitutional story in the paper, but that might not be right. If it is right, I think it gets rid of a lot of the practical problems we worry about with this kind of vague and uncertain doctrine. I mean, if the idea is don't only strike stuff down when you actually have a clear and stable understanding of why it's outside the enumerated powers, this isn't nearly as disruptive as you might think it is. But if we have some other set of presumptions, it might take us somewhere else. On Nathan's question about the Civil War changing things, I mean, my read, this is something I want to spend a lot more time on. My read is that a lot of stuff changes in how people think about federal power and think about the Constitution and think about the Union. And the hard question is the lawyer's question of to what extent those changes in thought are actually changes, sort of properly recognized as changes in the law. Because for a while, they also believe in stuff like the inherent powers doctrine, and there's sort of a big tone of enumerated powers, whatever, we're going to be a real country now, and not worry about any of the stuff in the Constitution. And I think, we've rightly receded from some of that and recognized that it doesn't have the legal force. But I think that's a big independent place to go into. On Barron and takings, some version of that could be right. I think that there are a lot of quirky things going on with the Bill of Rights in the states in the pre-Barron period. So there are Barron contrarians, people who just think that at least the elements of the Bill of Rights that don't say Congress apply everywhere. There's a related thing, which is kind of Bill Trainor's theory of Madison's purpose of the Takings Clause, which is that it will have kind of political force, that he'll put it in, and even if, as a matter of law, it doesn't apply to the states, once it's kind of in there and written down and everybody can see it, it'll become part of the kind of fabric of state constitutional law and common law and customary law, and everybody will think it's really important just because it's kind of written down where people can see it. And he says that about the whole Bill of Rights, that it's parchment barriers, but it doesn't matter because parchments turn out to be something really important when you look at them for framing effects. And that may also be what's going on, instead of a sense that there's a strict obligation to obey the Takings Clause, but I'm not sure.
A couple of very quick points in regard to Will's response to Nathan. I still come back to the dynamic concept of necessary. The way the change in federalism philosophy impacted the Constitution was through what was necessary now wasn't necessary then, and vice versa. And a quick response to Randy. I have a lot of trouble understanding the argument that while imprisoning, executing, and drafting are not great powers, making somebody pay for health insurance is.
So I'm going to cede 15 seconds to Larry Solom. Marty will not be able to reply.
So I don't think that the gap is devastating, and Will has an obvious move in response, which I will now offer to you, Will. So you can make an inference to the best explanation argument that the power of your evidence is so strong, right, that Therefore, it must be the case that whatever we ultimately determine the precise contours of the necessary and proper clause are, they have to include this great powers doctrine. That's essentially what you said, just sort of restating it. This is the same idea as a Kantian transcendental argument or transcendental deduction. Inference to the best explanation.
Actually, I have a devastatingly dispositive response, but I'm not allowed to give it. So.
That's right.
This margin is too small to contain it.
So the next group is Steve Smith, Michael McConnell, and Gerard Maglio.
Okay, my question has to do with something you alluded to just a moment ago, but I would like to hear you comment a little more fully on the connection between your paper and John McGinnis's from yesterday. And I was thinking that during John's session, because it seemed to me that each one could be seen as kind of testing and challenging the other one. When you talked about great powers, you concede, as Marty emphasized, that it's pretty hard to figure out really what would count as a great power and what wouldn't. Now, John's paper, it seems to me, would suggest that using the legal science, all the different tools and so forth, it should be possible to liquidate that or, come up with something like that. And then on the other hand, it looks as if you've kind of done that. You've tried to do the research and so forth, and you still are left with something that's pretty open as far as what would count as a great power or not, so that your paper could be seen, I think, as providing a kind of refutation to John's. So what do you, and the mandate, of course, that's already come up here is one instance that could be used to test that. I'd just be interested to hear what you think about that.
Michael?
I think this is a great, not like the lake, paper. But I wonder if it's at the wrong conference. Maybe this should be at the first annual Liquidation conference rather than Originalism conference, because it does seem to me that the thing about the paper that is striking and persuasive is the practice and not the text or anything about it seems to me you begin with a practice which is really quite remarkable, and then what you then show is you then provide some explanations about how the text and the original history might well be consistent with that. But I think if you didn't have the practice, the other stuff would not be very powerful standing on its own. So that if they had exercised eminent domain from the beginning, it would never occur to us to be making those arguments. So this is really a paper about liquidation. But like Larry Solomon, and I find it persuasive in many ways, but like Larry Solomon, I'd like to know a little bit more about what your theory of liquidation is. And it seems to me that there are at least three, and I can't tell, and they point in rather different directions, and I'd like to know, so one theory of liquidation is that the practice of those folks immediately or shortly after the adoption of a constitutional provision helps us to understand what its original meaning was, because it's close in time and they are operating in the same general world, and so it's evidentiary about original meaning, in which case early practice is very important and later practice doesn't matter very much. Or you might have a theory that, similar to some things that especially Jefferson seems to say, that it's the people themselves, it's their constitution, they are the ultimate interpreters, and that things like precedent and so forth gain force only when embraced and becoming a consensus of the people. And this might also fit with the McGinnis-Rappaport view that supermajoritarian processes have a certain force because it's supermajoritarian over time. That is, if you have a real consensus over a long period of time of popular institutions and what the people think, then it gains a force. Note that then, I think, allows for change. We're not asking what the meaning was at the beginning, but rather allowing the people to liquidate the meaning over time. And then a third possible understanding is that there are some provisions in the Constitution which appear to be based on normative criteria rather than rules. Things like reasonable searches and possibly great and independent substantive powers might fall into this. What is a great power? and that with respect to those things, that the reference is not, is understood never to have been frozen in time, but to refer to the consensual understandings of later generations. Not, I would stress, what 5 guys in robes happen to think, but what a genuine a consensus of the nation would think over time. And I think all those point in slightly different directions. And especially your paper is so striking because both eminent domain and also conscription have a solid practice early on, a liquidation that goes one way early on, and a fairly abrupt change, and then I would say an enormously powerful practice backed by public consensus for going exactly the opposite way for an even longer period after the change. And so, what liquidation theory should we be operating under?
And, sure, yeah.
Okay. So, my question is, can we explain the absence of federal eminent domain as being about preventing the taking of slaves? Now, I say this for a couple of reasons. One is, whenever there's an odd antebellum doctrine, I always wonder if it has something to do with slavery, right? Second is, this power is discovered during Reconstruction, which might be suggestive. And third is, at least there is some evidence that there was an understanding that emancipation would be a taking and that slave owners would have to be compensated, right? So when Congress abolished slavery in the District of Columbia, the slave owners were compensated. Now, that could have just been as a matter of policy, not as a matter of right. I guess if this is an explanation or partial explanation, does that then cast us in a different light? Because then it looks like a pro-slavery reading or liquidation rather than just one that's pro-federalism.
Okay, Will.
Yeah, so on Gerard first, I think maybe is the answer. There are some parts that kind of match that story and some don't. Like the anti-eminent domain folks are more likely to be Southerners than not, although not always. So like in 1860, one of the people proposing the federal eminent domain bill is Judah Benjamin. In 1864, one of the people arguing against federal eminent domain is Thaddeus Stevens. So if by then, it may not be a total sort of boxing match for federal emancipation power. I flirt with the idea that the Takings Clause may also be about slavery and emancipation. That another reason it's not weird to have a Takings Clause that focuses on a district and territorial power is those are the places where emancipation is the most in the air. There's also this question I bracket just because it's too much about whether the eminent domain arguments go just to land or go to personal property, which I'd have to sort of have a view about to know about the slavery question. Because also there are some comments that the federal government doesn't have eminent domain power over land, but it does over personalty, which presumably would include slaves if it were necessary and proper to some enumerated power, which would be the other thing that's missing. On Steve's question, I think the answer is the first 4 parts of my paper are not that connected to John's. I just sort of walk through what I can tell you about the original sort of theories and practice and materials. But the question of what to do with it, I think, is deeply connected to what presumptions and methods do we use to resolve ambiguity. And so you might say, if you're not sure, defer to Congress. You might say, use all available tools, though, to be sure, and those tools might include liquidation, and I think they do, which is why I think this is actually an originalist paper in addition to being a liquidation paper, because I think part of the original meaning of the Constitution, or at least interpretive principle that's sort of baked into the original meaning of the Constitution, is a version of liquidation, which is Michael's version 1 and a version 4 he didn't give. So one thing is liquidation is reflected light on the original meaning of the Constitution. A bunch of people write afterwards, the stuff they all take to have been obvious, that's an example of the kind of stuff that we should presume is baked in, although not always. We want to know why they thought it was obvious and whether there's something kind of funny going on. But then the other part of liquidation, which is not quite about normative criteria or about popular sovereignty, is really Madison's idea, that sort of part of what it is to have law is that you have provisions that are more or less ambiguous, that have zones of clarity and zones of ambiguity. And as to the zones of clarity, they're fixed from the beginning. Nobody can, no amount of practice, no amount of precedent can alter a constitution. But as to the zones of ambiguity, which are often, many, practice can fix the meaning of an ambiguous constitution. And that, I think that's just part of how the Constitution was originally expected to operate, and I think part of what we should see it to mean. I'm of two minds about whether that's really like a linguistic theory or whether that's a legal theory, and it might have some sort of minor implications which one it is, and that's something I'm still working on. I think it also still slightly leaves open the question of whether you can reliquidate. I think probably not. I think the idea is, for as long as the provision is open-ended, people kind of fight back and forth about it, and we see what the practices do, and a single practice, a single precedent doesn't settle it at all, but at some point, the practice and precedent becomes sufficiently uniform, especially when the sort of dissenters give up, that we should take it to be part of the meaning of the Constitution, and it's a mistake to change. And I did want to mention drafting, imprisoning, and executing. There's as powerful of a case against the enumerated power of conscription as there is against eminent domain. And there are judicial opinions striking down the Civil War draft under the necessary and proper clause in ways that are connected to eminent domain. Crime is really weird. The first Crimes Act actually is passed very early, and I kind of note that in the paper. But as I was going back and looking through it not that long ago, I noticed that all of the crimes are either are expressly enumerated things like piracy or counterfeiting and manslaughter in federal enclaves, or a weird batch of things related to kind of enhanced contempt of court. I'm not quite sure what's going on there. But it may well be that there's something fishier about the federal criminal power than I used to think.
Okay. Fourth group, Mike Rappaport, Tom Colby, and Bob Bennett.
Okay, so I think this is a great paper, as you know, Will. I've always, for the longest time since I first read Madison's Necessary and Proper stuff, I've believed in the great powers theory, and I think you really helped develop it. And I never actually thought it applied. I would have thought it applied to taking. So that's really the striking thing. I want to actually step back though a little bit and see if there is any help we can provide. It's not something that you do in the paper or that you should have. As to figuring out with originalist kind of sources what would be a great power and what might not be. I think we talked about this just a little bit, but so in a sense, it would be useful if we had sort of similar constitutions and see how they drafted them, right? So if we had, a Constitution, 2, and we looked at their drafting practices, we might be able to draw some inferences there. Not so easy to do that. So I just want to look at three things. So one would be the articles, right? So with respect to the articles, we know that they don't want very many implications being drawn in. So I think the only thing you can really say there is if the people in the articles, if the government had a power and it was not listed, if they were willing to infer it, then that's obviously not a great power. Or that would count against it being a great power because they would have implied it there, and very difficult to imply it. The other area you could look at would be state constitutions. To what extent were powers listed in those constitutions? And that might be sort of interesting, although my sense is if they're giving general legislative power, it's not 100% clear what's going on when they list the power. Maybe when they list the power, they're doing so for some other reason. Sometimes you list the power because there's other problems you want to clarify. So, but on the other hand, I think it would be useful to have a sense of what all the powers were that were listed in state constitutions. You might actually be able to derive some patterns. And the third area I guess I would look to would be treatises. Right? So it's obviously a very different question when we look at what executive power means, because we've got a straight vesting, no necessary and proper. And so that's very useful to look at, let's say, Blackstone, or when he has a listing of the executive power. So you could look at treatises and see what they listed. I mean, obviously, whether they listed something or not is not dispositive by any means, but presumably they would have listed the most important stuff. If they didn't list something, you might think that was not a great power. But in any event, I think there is sort of a next step to sort of take, at the very least, in trying to figure this stuff out, which is to look at things like this and see what inferences you can draw as to their thinking. Whether this would give you expected applications or other type of evidence, I'm not going to worry about.
Perhaps surprisingly, I want to take issue primarily with something that Marty said, which is, I'm sorry, but Lake Michigan is a great lake. It just is.
It's awesome.
I mean, Lake Erie, but Lake Michigan. But having said that, I do want to maybe echo and build on something else that Marty said, which is that if we take a version of originalism that is not looking at or not confining itself to expected applications, but we're more concerned about the original meaning of the words, and then extending that meaning in the modern world with the understanding that they might produce different results than we might have expected in the 18th century, then with necessary and proper, I think there's a pretty good argument that the federal eminent domain power is necessary today, even under the narrow definition of necessary that is rejected in McCulloch, because you have, in today's world, where there is a lot of animosity in large numbers of states against the administration, the federal government in general, federal policy, it may well be the case that the federal government simply could not get anything done if it needed cooperative federalism to do it, because a lot of these states will, just on principle, stick their thumb in the eye of the federal government any chance they get. So it may be that you actually, this is absolutely necessary, you cannot carry into effect some of the enumerated federal powers if you didn't have the power of eminent domain today. And if that were true, then it strikes me that not only does that mean that we would have to have eminent domain power today, even if we didn't in the 18th century, but it would also, I think, it would take down the propriety objection. That, oh, well, it's a great power, so it's not proper. As Marshall says, I think in McCulloch, one of the reasons why he wants to read necessary as broader than absolutely necessary is because then proper would be redundant or senseless, because if something is truly absolutely necessary, then you couldn't turn around and say, yeah, but it's not proper, because otherwise the federal government wouldn't be able to carry out its enumerated powers. So that's the reason why he says necessary has to be broader than absolutely necessary. But if this is absolutely necessary, then you can't turn around and say it's not proper, because that means the government can't carry out its enumerated powers at all. And so perhaps in today's world, employing a standard version of public meaning originalism, it must be the case that the necessary and proper clause gives the federal government eminent domain power, even if the framers expected otherwise in the 18th century.
Bob Bennett.
Oh, I was going to ask about what we do with necessary and proper if there was a consensus that it was redundant, but Larry Solomon already asked it.
Okay.
Well,
So this is good because I've failed to answer this question from Marty like 8 times now, and having Tom re-ask it reminds me to do so. So necessary and proper and evolving. I think it's probably right to think of necessary as evolving. I mean, the natural inquiry is, given whatever the circumstances of the enactment or its application now, is it needful? But I think the eminent domain objection, to the extent it has a sort of textual home, is in the proper side, and I think there's good reason to be more skeptical about the proper half being evolving. That the idea of having both requirements, or having what McCulloch describes as the means-ends connection and the spirit of the Constitution connection, I think the idea of having both requirements is that you can be very, very giving on the first requirement. It's quite broad, it depends on the circumstances, it's largely left to Congress's judgment, precisely because you have some kind of a fixed carve-out in the proper half on the back end. I mean, the ultimate inquiry of the great powers question is some version of, is this an elephant hiding in a mouse hole? Would allowing this to be an implied power somehow sort of do violence to the idea of enumerating the really important stuff? And I think having that, the broader your necessary powers are, the more need there is to have some kind of limiting principle on the proper back end. Some kind of theory about why stuff that seems kind of weird and crazy, and surely they couldn't have meant that, it isn't included just because there's some means-ends connection. As to how it actually applies, this is most of the material I cut out of the paper, but it's not at all obvious to me that federal eminent domain is more necessary now than it used to be. For one thing, the federal government already has a ton of land. So many of the projects you might think it needs to take land for, like it already has huge amounts of land. And I went on a kind of FOIA campaign with all of the agencies that are members of the Interagency Land Acquisition Council, just to find out, like, what do they take and, under what circumstances. And what a bunch of them said is they don't do it anymore. That eminent domain is expensive and politically controversial and annoying, and they already have a lot of land. So they mostly condemn things now for what they call friendly condemnations, where the person wants it to be condemned, but for some technical reason it's more helpful to have the government condemn it than to buy it. So if that is the inquiry, I'll just say I'm not at all convinced that it cashes out the same way now as you might think. As to Mike's question, I think, or mostly suggestion, I think most of those are right. I think those are good places to look. I think the other thing I would add are the sort of municipal law. I think the delegations of power to municipal corporations from the state may well tell us something about what kinds of things they thought they had to lay out and what they didn't. The one thing I'd add is I think the articles are a mess. There are strictly enumerated things, but lots of people, both at the time and afterwards, acknowledged they were kind of playing fast and loose. So somebody asked me this at some point, the Northwest Ordinance is passed under the articles, and it protects against takings power. So did that mean there was a takings power under the articles? But the answer is nobody can figure out why the Northwest Ordinance was constitutional under the articles, because there's no power described there to govern the territories either. And later on, Tawney in Dred Scott says, well, they just kind of did it outside the articles, and that was fine because they all agreed to it anyway. And there's the same fight about the bank where some people say the National Bank is okay because they did it under the articles, and Madison says, oh, we all knew that wasn't allowed. But this time around, we're actually trying. I do think that actually reminds us maybe a useful principle about liquidation, which is that liquidating practice is much more relevant when people are actually purporting to follow the Constitution than when they're in a regime where they may not even really be trying to apply it that much. And I fear the Articles was really kind of a fallen regime.
Can I just make one quick comment? I'm just mystified how everybody seems so uncritically willing to buy into the great powers concept. Well, can you just give me 2 examples where the Supreme Court even mentioned the concept? In all of the cases where it invalidated the exercises of federal power from the 19th century on, between Marshall's dictum in McCulloch and Gary Lawson, how many examples can you give me of where this was discussed in the Supreme Court?
Well, I can give you a couple things. So, it's pre-Gary Lawson would be Alden against Maine and Prince, both of which do refer to things being proper and not necessary, but they're using the exact same intellectual framework. They just didn't know quite what to call it.
That's the best you got?
No. So it's not a Supreme Court decision. It's not the U.S. Supreme Court, but it's the Pennsylvania Supreme Court when they strike down the Civil War draft on the grounds that it's outside of the scope of the necessary and proper clause because it's a circumvention of the militia power. They're relying on the same idea. They don't use the words great powers either. That may be more my language than theirs, but it's the same concept. And in Pollard's Lessee versus Hagan, which is the eminent domain case I talk about, again, what the Supreme Court says is the eminent domain power is one that the federal government doesn't have except in cases where it's expressly granted. And where is it expressly granted? In the district and the territories and nowhere else. Now, it's a reliance on express grants, which is the same principle. Again, they don't use the word great, so maybe I ought to start referring to mine as something like the clear statement rule, but that would just be confusing because there are a lot of other clear statement rules. But I think the idea is in action from 1845 to 1865 to 1997.
So, with some optimism that I didn't think was, we are down to our last troika. So, but you have 5 minutes. So it's Lori, Stephen Sachs, David Upham.
So, is spending a great power? If spending's a great power, isn't Madison hoisting his own petard by having said that, spending is an incident of the specific heads of power, and that's really the only basis on which you can do it? And we've got the problem that, Hamilton's argument that prevails is based on this, curiosity that we're taking just the express purpose of the taxing power as the basis of the spending power. Where are we getting it from, and how does this fit into a Madisonian great powers theory?
Stephen?
So, my question is in part related to sort of pushback on Larry Sullivan's question, and also a sort of pushback against sort of putting too much weight on the words necessary and proper. And so it's possible, as I understand the Lawson-Nadelson argument, it's that this clause is an implied powers clause in the way that Cale Nelson argues that the supremacy clause is a non-obstante clause, and Eugene Volokh says that the first part of the Second Amendment is a prefatory clause. So there's a thing. It's called an implied powers clause. We've got lots of ways of saying it. They're all basically identical to each other. And we don't really put too much weight on whether we said necessary or necessary and proper or whatever, because we all know that that's, so that is the, whether you want to call it sort of intended meaning or the original public meaning, so that is what every, reader would understand is going on here when we put it in. So that's, I think, the Lawson-Nadelson claim. And so my first question is, would that help get around some of the, so what kind of originalism are you doing here? Are you really interpreting the text? And you can say sort of yes, because sometimes text comes in big blocks, and not necessarily at a sort of word level or even sort of a phrase level, if that makes any sense. And then the second half of this question is, if Lawson-Nadelson are right about that, sort of echoing something that Marty is asking, sort of where did it go? Why is this language used by sort of Randolph in 1791 and Madison and Marshall and all the other people that Lawson-Nadelson cite, but it just isn't used very much by mid-century or so?
David?
Just a couple things about just a general comment of the paper. I thought it was fantastic, and I found it at least compelling enough to provoke further inquiry. Again, to what extent? If you have, I thought your best textual argument was just simply the fact of the taxing power, because that's absolutely necessary to everything else. And why would it need to be separately enumerated? Necessary, and if absolutely necessary means proper as well, then you don't need it. In terms of researching, this issue, there's a couple sort of historical things you might want to maybe just a footnote, or maybe even in the text. Going back before the state constitutions, Magna Carta has a whole series of numbers dealing with takings and the ways in which the king can coercively take discrete property as opposed to general taxation. The second is the implications of the quartering. I don't know, I don't understand what the implications would be, but the Third Amendment, which is a temporary coercive taking that's involved. The third also is the implications, and again, this might cut both ways, but of the debates over the purchase, the voluntary purchase of the Louisiana territory. Why was that so complicated? Maybe the very fact that there was a controversy over that voluntary purchase of foreign territory might lead to some implications as to the power to coercively purchase domestic territory.
All right, Will, you have 1 minute.
Okay. I think the Louisiana Purchase is a different thing because it's about the acquisition of, jurisdiction is as important as the acquisition of title in that circumstances, but maybe there's something there. I think the Third Amendment rises and falls a lot like the Fifth Amendment. I think I basically agree with Steve's friendly amendment about implied powers clauses. I haven't done enough of the work to know where it went, although I do notice that the words incidental powers keep popping up over and over in the 1860s in the eminent domain debates there, so it wasn't totally gone, although maybe it was forgotten. And spending, I don't know. Madison must have thought it wasn't a great power, or else he couldn't have thought it was implied in each of the enumerated powers. I want to figure out what I think about the spending clause, and I don't have a clue. There is also the suggestion that it's part of the property clause, although I think that's kind of an idiosyncratic way of thinking about it. And finally, I guess David said something that reminded me to say this about the burden of proof. I think it's totally fair to ask whether I've met whatever the burden of proof is for sort of proving the law. I have no idea what the burden of proof is or whether I've met it. Since I was going against what seemed like a 100% wall of conventional wisdom, I felt like any dent out of it I could take would be an achievement. And whether I've met the preponderance of the evidence standard or not, I have no idea, and that's fair enough to wonder.
So let's thank Will and Marty. Take care.